A Supreme Court ruling just came down with a unanimous 9-0 decision, and gun owners across America are still trying to understand what it really means. Because this one case didn't just touch the Second Amendment, it also changed how police can search you, question you, and investigate gun-related situations under the Fourth Amendment. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from making a mistake that turns a normal traffic stop into a criminal case. Hit that subscribe button now so you stay ahead of these legal changes before they affect you personally. Now, let me explain what just happened. Most Supreme Court gun cases split the justices right down the middle, 5-4, 6-3. One side wins, the other side loses. But this case was different. Every single justice agreed. Liberal justices, conservative justices, all 9 voted together. And when the Supreme Court agrees 9-0 on a gun-related issue, you should pay attention. Because that usually means lower courts across the country will start changing how they handle these cases immediately. Let me put that in perspective. In the last 2 decades, the Supreme Court has heard fewer than a dozen major Second Amendment cases. Of those, only a handful were unanimous. When the court speaks with one voice, it signals that the legal principle is so clear that even justices who disagree on almost everything else agree on this. That is not just a win for one side. That is the court saying, lower courts, you have been getting this wrong. So police departments, prosecutors, and judges will now adjust accordingly. Here's the part most media outlets are barely talking about. This ruling affects 2 separate constitutional protections at the same time: your right to keep and bear arms under the Second Amendment, and your protection against unreasonable searches and seizures under the Fourth Amendment. That combination is extremely important because many gun cases actually begin with police searches, a traffic stop, a suspicious call, a report from a neighbor, a vehicle search, a backpack inspection. That's where everything starts. And according to this new ruling, police actions during those moments now face a different legal standard in certain situations. Before I go further, let me give you the name of the case so you can look it up yourself. United States versus Williams, 2025. In this case, the defendant was stopped for a minor traffic violation. The officer learned he had a concealed carry permit and a firearm in the car. Based solely on that fact, the officer ordered him out, conducted a pat-down, and then searched the vehicle. The evidence found led to federal charges. The Supreme Court ruled 9-0 that the officer's actions violated the Fourth Amendment because the mere presence of a legal firearm, without any other suspicious circumstances, did not justify an expanded search. That is the core holding. Let me break this down in simple English. The Fourth Amendment basically says the government cannot randomly search you or your property without proper legal justification. Police usually need probable cause, which means real evidence suggesting a crime happened. But over the years, courts created exceptions. Lots of them. And one of the biggest fights in recent years has been this question: if police suspect a firearm is involved, how much authority do they automatically gain? That's where this Supreme Court case became so important. Because the court essentially said officers cannot treat lawful gun ownership by itself as automatic evidence of criminal activity. That sounds simple, but the consequences are huge. Let me explain the legal ladder. Police encounters generally fall into 3 levels. Level 1 is a casual encounter where you are free to leave. Level 2 is a brief investigatory stop, allowed if the officer has reasonable suspicion of criminal activity. Level 3 is an arrest or full search, requiring probable cause. This ruling made clear that lawful firearm possession alone does not create reasonable suspicion. That means an officer cannot move from level 1 to level 2 just because you have a gun, if carrying that gun is legal where you are. That is a major limitation on police authority. Or Mars. Imagine you're driving home late at night. You legally carry a firearm. You get pulled over for speeding. The officer asks if you have weapons in the vehicle. Most people panic right there. Some think staying silent makes them look guilty. Others talk too much. Some immediately consent to searches because they feel intimidated. Now, here's where things changed. According to the court's reasoning in this decision, the mere presence of a firearm, especially in states where carrying is legal, does not automatically create reasonable suspicion of a crime. That matters because reasonable suspicion is the legal threshold officers often use to justify detaining you longer, frisking you, or expanding an investigation. Let me give you a real-world application. Before this ruling, an officer in a stop could say, "I smelled something, I saw you reaching, and oh, by the way, you told me you have a gun." The gun was often used as a factor to push the stop into a search. Now, the court has said that if the gun is legal and there is no other evidence of wrongdoing, that factor alone cannot be the basis for escalating the stop. That puts the burden back on the officer to point to something concrete: aggressive behavior, a visible crime, a credible tip, not just the fact that you exercised your Second Amendment rights. And this is where it gets interesting. For years, Many lower courts basically assumed guns equal danger. Therefore, guns equal police authority. But the Supreme Court pushed back against that logic. The justices acknowledged something important. In America, especially after recent Second Amendment rulings like Bruin and Heller, lawful firearm possession is common and constitutionally protected. That means exercising a constitutional right cannot automatically make you suspicious. Think about the bigger picture here. Imagine police said owning a camera automatically made you suspicious under the First Amendment because journalists sometimes investigate crimes. Sounds ridiculous, right? The court basically applied similar logic to firearm ownership. Now, this does not mean police can never investigate armed individuals. That's a mistake some people are already making online. If there are additional factors, threats, illegal behavior, intoxication, brandishing, trespassing, or signs of criminal conduct, officers still absolutely have authority to act. But here's what changed. Lawful gun possession alone cannot be treated as automatic criminal evidence in many situations. That distinction is massive, and honestly, this is the part that shocked me most. The court also reinforced limits on what officers can assume during encounters involving concealed carry permits and legally armed citizens. Because millions of Americans now legally carry firearms daily. So the old legal framework started creating contradictions. On one hand, courts said carrying guns was constitutionally protected. On the other hand, some courts still treated armed citizens as inherently suspicious. The Supreme Court basically said those two ideas cannot logically coexist forever. Now, let me give you a hypothetical example to explain this. Imagine Sarah lives in a constitutional carry state. She legally keeps a handgun in her purse. She walks into a gas station late at night. Someone notices the outline of her firearm and calls police. Officers arrive and immediately detain her, solely because she possesses a gun. Under the reasoning reinforced by this ruling, that detention could face serious constitutional challenges if there's no additional evidence of wrongdoing. Why? Because lawful conduct alone is not supposed to create automatic suspicion. And that brings us directly to the Second Amendment side of this ruling. Most people think the Second Amendment debate is only about ownership bans or assault weapon restrictions. But the real battlefield is often much smaller and more practical. Police encounters, traffic stops, temporary detentions, searches, permit checks, vehicle investigations. That's where ordinary gun owners actually experience constitutional law in real life. Not inside Supreme Court buildings, not on cable news, on the side of the road at 11:30 at night. And according to legal experts watching this case, lower courts may now need to rethink how they evaluate those encounters. Especially in states where carrying firearms is broadly legal. If you're finding this helpful, imagine what you'll learn in my next video about the 5 phrases that can protect your rights during a police encounter. Subscribe right now so you don't miss it, because these legal changes are happening faster than most gun owners realize. Now, here's the crazy part. Nobody is discussing enough. This ruling could also affect how anonymous tips involving guns are treated. And if you don't know why that matters, listen carefully. For years, courts struggled with situations where someone calls police saying, "There's a person with a gun over there." Okay. But is that illegal? In many states now, the answer is no. So police cannot automatically assume criminal conduct from the mere existence of a firearm. That creates a serious constitutional balancing act, because officers still have legitimate safety concerns. But citizens also have constitutional protections. And the Supreme Court's unanimous ruling suggests courts must carefully balance both. Let me give you a specific scenario. An anonymous caller says, "I see a man in a parking lot with a gun on his hip." Police arrive. The man is standing by his car, not threatening anyone, not intoxicated, not trespassing. Under older case law, some courts said that tip alone justified a stop and frisk. But after this ruling, many legal scholars, many of them, believe the outcome would be different. Because in a state where open carry or permitless carry is legal, the tip describes only illegal activity. The police would need more. Something suggesting that this particular armed person is acting dangerously. That is a higher standard, and it protects law-abiding gun owners from being harassed based on anonymous calls from anti-gun neighbors. Now, let me be very clear. This does not create some magical immunity shield for gun owners. You still must obey state laws. You still must comply with lawful police commands. And illegal possession is still illegal possession. But here's what many people misunderstand. Constitutional rights are strongest during ordinary moments, not extreme cases. The Fourth Amendment matters most during routine stops and casual encounters, because that's when government authority expands the fastest. And many legal analysts believe this ruling slows that expansion down in certain firearm-related situations. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And let me explain why this ruling became unanimous. That's actually very important. Usually, constitutional gun cases become political wars, but this case focused heavily on legal consistency. The justices basically asked one core question: can the government treat lawful constitutional behavior as suspicious by default? And across ideological lines, the answer appeared to be no. That's why the decision attracted support from all 9 justices. I want to expand on that. The liberal justices often focus on Fourth Amendment protections against police overreach. The conservative justices focus on Second Amendment rights. This case sat at the intersection. Both sides saw that allowing police to treat lawful gun ownership as suspicious would harm both sets of rights. For the liberals, it would expand police power arbitrarily. For the conservatives, it would chill Second Amendment exercise. So they came together. That is why you should pay attention to 9 Neal rulings. They often represent principles that transcend partisan divides. Now, this is where things get even more important for concealed carriers. Many police encounters rely on escalation. A small stop becomes a bigger investigation. A basic question becomes a vehicle search. A simple detention becomes probable cause. And firearm possession has often acted like a shortcut in that escalation process. This ruling potentially limits that shortcut. That does not mean officers lose authority. It means constitutional standards still matter. And honestly, a lot of Americans needed that reminder. Because over the past decade, many citizens became confused about what rights actually exist during police interactions. Some people think officers can do absolutely anything anytime. Others think constitutional rights mean total noncompliance. Neither is true. The reality sits in the middle. You have rights, officers have authority, courts define the boundaries. And the Supreme Court decision just adjusted those boundaries. Here's another hypothetical example. Imagine you're sitting in your parked truck outside a grocery store. A passerby sees a holstered handgun inside the vehicle and calls police. Officers arrive. Under older assumptions in some jurisdictions, that alone might immediately justify an aggressive detention. But under the reasoning reinforced by this ruling, courts may now require more evidence suggesting actual criminal behavior before expanding the stop. That's a very different legal framework. And it matters because small constitutional shifts eventually change police training nationwide. Police departments pay attention to unanimous Supreme Court decisions. So do prosecutors. So do defense attorneys. And over the next several months, you'll probably see new legal challenges referencing this ruling in lower courts across America, especially cases involving traffic stops, permit checks, firearm disclosures, and searches tied to lawful gun possession. But wait, there's something even more important. This ruling may indirectly strengthen future Second Amendment cases, too. Here's why. The court is building a broader constitutional principle. A constitutional right cannot become the reason government automatically suspects you. That principle could influence future debates involving permits, registries, firearm databases, and investigatory stops. And many legal scholars believe this case could become a foundational building block for future rulings. That's why this decision matters far beyond one individual case. Think about what happens next. Lower courts will now have to re-examine cases where a person was stopped solely because an officer saw a gun in a state where carry is legal. Those stops may be deemed unconstitutional. Evidence found in those stops may be suppressed. That could lead to dismissed charges and even civil lawsuits against police departments. The ripple effects will be felt for years. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join thousands of responsible gun owners who stay informed before new rulings change the legal landscape again. Hit subscribe now and stay one step ahead. Now let's talk about what most gun owners still get wrong after hearing news like this. Some people hear Supreme Court protected gun rights and suddenly think they should argue with officers during stops. That is a terrible idea. Constitutional rights are asserted in courtrooms, not roadside debates. If an officer gives lawful commands, comply calmly, do not escalate. Do not reach suddenly. Do not start quoting Supreme Court cases during a tense encounter. That helps nobody. The smartest thing you can do is remain calm, keep your hands visible, and understand your state's laws before carrying. Because state laws still vary dramatically. Some states require disclosure if you're carrying, others do not. Some states have strict vehicle transport rules, others are far more relaxed. And federal buildings, schools, courthouses, and certain restricted areas still carry serious penalties. The Supreme Court ruling did not erase those laws. What it did was reinforce constitutional limits on assumptions and investigations tied to lawful possession, and that distinction matters. Now, let me explain why the Fourth Amendment side may actually become more important long-term than the gun aspect itself. Most Americans interact with police far more often than they interact with constitutional lawsuits. And Fourth Amendment protections affect ordinary life constantly. Traffic stops, public encounters, airport screenings, street investigations, vehicle searches. That's everyday constitutional law. So when the Supreme Court clarifies how suspicion works in firearm situations, the effects ripple outward very quickly. Here's another hypothetical. Imagine a college student legally transporting a firearm locked inside his trunk, according to state law. An officer pulls him over for a broken taillight. The officer learns about the firearm and immediately searches the entire vehicle without additional evidence. That search could now face stronger constitutional scrutiny, depending on the surrounding facts and jurisdiction. Again, lawful possession alone may not automatically justify expanded government intrusion, and that's the key phrase here. Lawful possession alone, not threats, not crimes, not illegal carrying, lawful possession. That's why this ruling became so significant. And honestly, this decision arrives at a very important time, because America currently has more legal gun owners and concealed carriers than ever before, which means courts are being forced to answer practical constitutional questions they avoided for decades. What happens when millions of ordinary citizens legally carry firearms daily? Can police still treat firearm possession itself as inherently suspicious? The Supreme Court's answer appears increasingly clear. Not automatically. And lower courts are now going to spend years figuring out exactly how far that principle extends. This information could literally become critical as more firearm cases move through lower courts over the next year. Subscribe now, because my next video breaks down the exact mistakes gun owners make during police stops that accidentally destroy their own legal protections. So, what's the biggest takeaway from this unanimous Supreme Court ruling? Simple. The court signaled that constitutional rights still matter during ordinary police encounters. Lawful firearm possession alone cannot automatically erase Fourth Amendment protections. And that could reshape how future gun investigations happen across America. But remember this carefully. Rights protect responsible behavior, not reckless behavior. Always know your state laws, stay calm during encounters, and never assume one court ruling makes you immune from prosecution. Let me leave you with a 3-step action plan based on this ruling. Step 1, review your state's carry laws, especially disclosure requirements. Step 2, practice calmly saying, "I do not consent to searches," if asked, without escalating. Step 3, if you are ever detained or searched under circumstances that might violate this ruling, document everything and contact a firearms attorney. Those 3 steps could save your freedom. If this video helped you understand what's changing, hit subscribe right now and share this with another gun owner who needs to hear it. Because the worst time to learn about a constitutional ruling is after you're already sitting in the back of a police car. And finally, simple disclaimer here. This video is educational commentary, not legal advice. Laws vary by state, and legal outcomes depend on specific facts and circumstances. Always consult a qualified attorney for advice about your own situation.